ओम पूर्णमदः पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णस्य पूर्णमादाय पूर्णमेवावशिष्यते. Om Shanti, Shanti, Shanti. O Lord, this outer world is full with divine consciousness. The inner world is also full with divine consciousness. From the fullness of divine consciousness, the word is manifested, taking Pun from Pun, remains indeed Pun, because divine consciousness is one, undivided and infinite. Honorable President of Manipal University, Jaipur, in absentia, respected Director and Head, School of Law, Professor Dr. Vijay Lakshmi Ji Sharma, respected Coordinator, Dr. Sunita Ji Khatena, learned faculty members online and in absentia, dear students and everybody present online in this webinar. A very good morning to all of you, sir, and the students. In this session, we will briefly discuss and try to understand the challenges to legal education in the changing scenario due to use of computer, laptop, smartphone, internet, Wi-Fi, hotspot, email, social media sites, banking sites, online banking, banking through cards, email and other applications available through internet access. So the present time, the working in all domains, including the education domain and administration of criminal justice, is enveloped, totally enveloped with the fast development in the information and communication technology. The electronic data interchange and other means of electronic communication is being used as an alternative to paper-based methods of preparation, processing and storage of information. This is very important. The new transformation, this is the paradigm shift, and these transactions and information in the digital form are in the virtual space, which is intangible in nature. Now, we will discuss first what is cyber era, because it is in the cyber area, the legal education in the changed cyber era. Then what is the cyber era? What is the impact of this information communication technology on the present day happening? What is the existing curriculum of legal education in law universities? How much the present legal education system is compatible to address the challenges and impact of cyber or the cyberspace? If not, what changes are required to address the present scenario impacted by cyberspace? Suggestions to conquer the challenges, and last, how and who can do what? First, we see what is cyber. Cyber is intangible and virtual in nature and can be defined as the characteristic of culture of computers, computer system, information technology, virtual reality and artificial intelligence. And then cyber era. What is cyber? So cyber era is defined, may be defined as the computer technology driven high-tech information era in which we are living today. Then comes the cyberspace. What is cyberspace? We may define as it is the global virtual domain in the information environment consisting of information system infrastructure, which includes computer, computer system, internet, telecommunication network, embedded processors, controllers and their interdependent network. The menace of the misuse of this computer and internet technology, it is very common and is known to everybody and seen in day-to-day life. There are innumerable victims and sufferers of cybercrime these days, and those who are not sufferers, the lucky ones, are also in panic when they read in the newspaper or watch on the electronic media the stories of cyber violence. I am sharing a few of these cases which have been reported in the papers, though there are a lot many, and these examples will explain the modus operandi, the trajectory and the gravity of the cybercrime. Now, may I permitted to share the PPT on your screen. So the first case you see, the girl who kidnapped, murdered her Tinder match reveals chilling details in terrifying candid interview. So in this particular case, a 27-year-old very intelligent girl from a respectable family registered herself through internet and her smartphone on the social media platform, that is Tinder, without knowing the characteristic features of the social media platform. Later on, she became victim of cybercrime and was booked for committing kidnapping, extortion and murder. The moral of the story is, the girl was innocent and ignorant about the safe use of cyber computer resources and about the cyber law and social media platforms. And it happened because of the lack of knowledge and understanding. Now, the second case, you can see on this. In this case, cyber coup dupe ex-CGI loadout rupees 1 lakh. In this case, the retired Chief Justice of India, Justice Lodha, received an email claimed to be sent by one retired Supreme Court Judge, Justice BP Singh, and request was made for an urgent need for 1 lakh rupees for his cousin's treatment. It was also a case of cybercrime, cheating through spoofed email, identity theft and hacking. Third case, this is a different type of case in which the ex-Delhi University Vice Chancellor, he was held for plagiarism and theft of intellectual property using the computer resource and internet. Then in the fourth case, the girl used to come for coaching with her boyfriend, and her boyfriend put photos and videos and shared the obscene photos and videos for blackmailing her. In this case of recording and distribution of electronic form, a case of cybercrime of non-consensual sharing of sexual contents without permission. He shared it without permission. And then cyber harassment, she was harassed, cyber blackmailing, cyber defamation and cyber pornography. And the next case, in this case, this is the case of gendered violence of fake ID, non-consensual sharing of image. प्रेमिका से ने रिश्ता तोड़ा और बॉयफ्रेंड ने फोटो एडिट करके सोशल मीडिया पर डाली और बता दिया सेक्स वर्क. So it's a cyber case of fake ID, non-consensual sharing of image, cyber morphing, cyber blackmailing, cyber pornography and cyber dating abuse. Now the next case is that is महिला संचालित कर रही है साइबर जालसाजी का गिरोह. This is the case of cyber banking fraud through WhatsApp hacking. These are available, they are published in the papers, the newspapers. Then in Corona call में cyber crime महिलाओं को बना रहे हैं आसान निशाना. A case of gendered cyber violence. The gendered cyber violence, what is the gendered cyber violence? In which the violence against a woman or girl child perpetrated through the computer resource or the internet and communicated by the internet and again received by the victim on her computer resource she is using. That is so this is the case of gender cyber violence. Then second, next case है, हेलो सर, मैं मोबाइल कंपनी से बोल रही हूँ, आपकी सिम को अपडेट करना है और मैसेज भेजते ही खाते में 69,000 निकल गए. You daily see these messages and the type of cases. This is a cyber crime case of financial fraud through phishing. So the modus operandi is phishing. Now the next case, all these are the different cases. The data scientist ने दिल्ली चुनाव में पकड़ा था छेड़छाड़ का नेटवर्क, फेसबुक रहा चुप. So in this case, it's a computer crime. Using the computer, he did all that forgery and And next is about the हो जाए alert बिना OTP किया कंगाल. So in this case, even it doesn't need the OTP. Using the tools, it's a case of bank fraud. And then again the next is a की सिस्टम हैक करके गाड़ी चुराते फर्जी कागजात पर दूसरी चाबी ले लेते हैं. Again a case of cyber crime, hacking, theft of vehicle, the identity theft, forgery, cheating, etc. इंटरनेट पे मिल रही है फर्जी डिग्री, पैसा दो, बैकडेट की डिग्री दो. साइबर क्राइम केस ऑफ फोर्जरी एंड चीटिंग. We see in all these cases, and like so many other cases, if we analyze, there is one thing common. The common thing is the use of any of the computer resources. What are the computer resources? A computer or smartphone or internet or Wi-Fi. So the computer resource or internet is used in committing the crime, or the computer resource itself is attacked, or the computer resource was present at the scene of offense. These three things, the ingredients should be there, either with the help of the computer resource, or computer resource was attacked as a target, and second, it was present on the scene of offense. Why? Because when it is present on the scene of offense, the digital evidence is recorded in the digital device. So that is the result. Similarly, there are presence of digital evidence in all the crimes discussed just now. Now we come to discuss the existing legal education system. So what is the scenario we have discussed because of the impact of cyber? The scenario is quite different. Now come to the existing legal education system. What is the existing legal system? A student of law, when enrolled in any university, studies the subject as per the syllabus of the university. Now, who decides the syllabus? The university is bound by the Bar Council of India and state bar councils. The Bar Council of India and state bar councils in the present legal system, they prescribe the standards of legal education. The course contents of the syllabus, the examination and evaluation of paper is also prescribed by the Bar Council of India with the effective consultation. They have to consult the university and the state bar council. But when it is fixed by the Bar Council of India, then the course will run, the same course will run in all the universities. In the present scenario, the two systems are operating in Rajasthan simultaneously. One is the 5-year integrated course and one is the 3-year LLB course after graduation. And this 3 years graduation course is existing since 1967, the present one. And the 5 years integrated law degree course after senior secondary education, which is there since 1987. Now we come to the Manipal University, to your university. I am audible? Am I audible?
Yes, sir. Yes, sir.
Okay, thank you. Now we come to your university in which you have enrolled yourself for the legal education. In Manipal University and in all other universities of Rajasthan, you might have gone through the syllabi which is available on the website in the 5 years integrated course. We are discussing the 5-year integrated course first. So I have gone through this. I saw what I observed. There are 59 papers to be cleared in the 10 semesters with a total of 242 credits. 59 papers, 10 semesters, 242 credits. We go through the curriculum, the papers on the law subjects. Legal studies are the labor law, the constitutional law, the family law, the company law, international law, law of crimes, criminal procedure code, law of evidence, law of jurisprudence, civil procedure code, law of property and easement, land and tenancy law, law of intellectual property, then human rights, law of anti-corruption, law on right to information, law on banking, law on transportation, law on stamp duty, and law on limitation. And one paper, you see only one paper on cyber law out of the 59 papers, and only 4 credits out of 240 credits. This is nothing from my side. This is available on your website. Why I have analyzed this. What is the present scenario of the legal education? And one university can't be blamed. It is all over like this. Question is whether our existing legal education system is adequate enough to meet the coming challenges, for which we will do the gap analysis between the existing course curriculum for the law studies and the expectations of stakeholders of the society from the law graduates. Who are the stakeholders? The public at large, the corporates, the courts, the litigants. They are the stakeholders. And the challenge is, I think when we analyze it, probably we are not able to bring into the syllabus of legal studies of cyberspace or the world of global virtual domain. Cyberspace is the world of global virtual domain of networking and computer system. And we are not able to bring into the clutches of the law and within the ambit of legal education. As we already saw, out of 59 papers, we have only one paper for cyber. While the society in the present times is living in we are comparing it. That is the what is there in the course, and the society is living in the environment of computerization, in which worldwide website, www, internet, your e-banking, e-commerce, e-learning, work from home, use of augmented reality in training, surgery, medicine, and e-learning, e-examination, and all other such activities, even your booking, all your bookings, they are online booking. They depend on cyber, internet, and computer resource. They have become part and parcel of our lives. New methods of committing online frauds, online cheating, cyber defamation, cyber harassment, cyber threatening, cyber blackmailing, cyber bullying, cyber stalking, cyber provoking, cyber defamation, cyber grooming, online solicitation, online personation, transmitting obscene photos, obscene videos, online pornography, cyber social network fraud, cyber identity theft, cyber unauthorized system access, cyber dating abuse, which we have already seen, cyber morphing, internet piracy, cyber terrorism, transnational organized crimes, white collar crimes, frauds related to intellectual property like copyright, patents, domain names, copy theft, gendered cyber violence, another type of violence, different type of violence, and other cyber crimes come into the existence in abundance, innumerable number. If you visualize the situation of a lawyer in the galaxy of dynamic variety of e-crimes with the different modus operandi, in the present time, the knowledge of law and their implementation is the biggest challenge before the lawyer, because of these laws and their implementation is not properly incorporated in the legal education. Adequately incorporated in the legal education, the knowledge of adequate and skillful law and its implementation in the area of information communication technology is the need of the hour, as I think. And I think you all people agree with me, may or may not, but what I think, it is the need of the hour. The impact of this virtual information communication technology, or we can say the advancement of this virtual information communication technology on the administration of justice is revolutionary. For the last 3, 4, 5 months, we saw all the courts were closed. Whatever urgent hearing was, it was online. The learned judges from outside India, anywhere from the world, from London or from elsewhere, they were pleading their cases. In imparting justice, the main focus and fulcrum of the justice, what is the main focus and fulcrum for the justice system is, that is on evidence. And this evidence is either oral or documentary. And the oral and documentary evidence should be admissible in the court of law. So now if you say the Indian Evidence Act, who has studied Indian Evidence Act, so section 60 of the Evidence Act says that only direct oral evidence is admissible. And section 64 of the same act, Indian Evidence Act, says that documentary evidence is admissible only in the primary if it is original. Otherwise it is not admissible. Now we come to the evidence, the digital evidence. Digital evidence, when the act is performed with the help of computer, based on the communication technology and the information or the we can say the evidence is prepared, processed, communicated with the help of computer resource or internet, and is also stored in the memory of the computer and then converted into the document with the help of the printer. The document that comes out from the printer, it is not primary. It doesn't remain primary, but it is secondary. So how to make it admissible in the court of law? We have the different process. Similarly, the oral evidence perceived by the organs of the senses, the section 60 of the Evidence Act says it should be perceived from the person who deposits the evidence from his organs, his or her organs of senses, the eye, what I saw, ear, this I hear, tongue, eye tasted, nose, eye smelled, skin, eye touched. Of the person who perceives by the organs of senses and deposed before is a primary evidence. In the era of cyber, it is all virtual, hence cannot be perceived directly by the organs of senses of human being. So the oral evidence is also not direct and not admissible. It is the biggest challenge in the domain of administration, and the biggest challenge is how to identify the virtual or the digital evidence in the digital devices which are in the process of committing crime, and the digital evidence is available in them. Then how to extract or see the virtual digital evidence from the digital devices, then how to procure it, how to preserve it, how to transfer it, transfer the digital evidence and virtual evidence. This is for the, and how to analyze this digital evidence, because it is all virtual, it is intangible, and then how to transfer this document, and last, how to submit in the court of law in a way that this is relevant. Number one, the evidence should be relevant. So only the relevant evidence has to be identified and to be extracted and submitted in the court of law. Then it should be reliable. Means in the process, the integrity should be intact. It should not be compromised. And third, it is legally admissible. It should be admissible as per law, because there is different law for the electronic evidence. In all the process, the use of authenticated reviewed technology and procedures, the different type procedures and the tested tools What are the tools? Tools are the software programs. They are called the tools. So all these tools, they should be used in a legally authenticated way, that is, its integrity remains intact and it is legally admissible in the court of law. So since the changes in the syllabi of legal education cannot be amended and by the university itself, this needs Bar Council of India and the recommendation of universities and state bar council, which has its own protocol and may take an optimum time. Without amendment in the syllabi, the universities are constrained not to go beyond the subject mentioned in the syllabus. This is again the problem. So, how to address this challenge? The present scenario, every student of legal education, even a common student and especially the legal student, is using computer, laptop, smartphone, then he is accessing the internet, using the Wi-Fi, hotspot, email, websites, mobile applications, banking applications, and all other social media platforms. He is very busy on registering on the social media platforms, online internet games, movies, and internet platforms available on the internet. But because of the lack of knowledge of safe use and safety precautions, he may become victim of cybercrime inadvertently. Lack of knowledge, he becomes a victim of cybercrime inadvertently. So it is very, very essential in the present time of cyberspace that every student, and including the law student, must know the safe use of all these computer resources, internet and communication devices, and in spite of all precautionary measures, if he or she happens to become the victim of cybercrime, then again the question is what to report, where to report, whom to report, what law is applicable to this kind of crime, what type of crime is, what is the modus operandi. You being the law graduates, the public, the society, your family members and the organization in which you will be working, they expect that you will guide them what to do, what law is applicable, what type of evidence you will collect, where will you get the evidence. You have to guide all that. And the legal education should also include some more contents on the cyberspace in the curriculum of legal study. This is my view. It is expected from the law graduate to know the terminology of legal devices which are used in the cyberspace. They are very important. They should know the terminology of legal devices which are used in the cyberspace for preparation, for analysis, transmission and storage of information. After all, information is the evidence. That is the only evidence. You should also know the terminology, the modus operandi and the trajectory of cybercrime. He should know, it should be in his knowledge what is the trajectory of crime, what is the modus operandi of crime. And since these are not included in the present legal education, but little knowledge I have, and I have gone through the course curriculum, and it is common for all the law students in all the universities. But when the law graduate appears before any corporate body or gives consultancy on prevention, mitigation of cybercrime, or he guides on the case of cyber security, how to maintain the cyber security, what is cyber security, how can we do it, what is the procedure, what are the ingredients to protect the information or the devices where the information is contained. And the law graduate, second time when he appears in any court of law in assisting the interpretation of legal ingredients pertaining to cyber law, or the assistance in the relevancy, reliability and admissibility of digital evidence, it is not excusable that these were not in the curriculum. He must have the knowledge of all that. So, The challenge before the students, the next challenge, what to do, how to meet the challenge, who will teach them when it is not in the curriculum, how to go. So the solution is you have to follow Eklavya. I hope everybody knows the story of Eklavya, the son of a poor hunter and exemplary discipleship character of the epic Mahabharata. Must have heard the story of Eklavya. He was deeply desired to study the archery from the Dronacharya to save the deer in the forest that were being hunted by the leopards. That was the purpose. It was not purpose to kill the man. It was just to save the deer from the leopards. But the law, rules and protocol of those days did not allow Eklavya to learn archery from the Dronacharya, and Drona was also forbidden to teach by the protocol of that time rules, because they decided the curriculum, the entry rules, the examination and all that. They was deeply desired to learn the advanced military arts of archery. He did not leave hope. Eklavya, in the presence of virtual Guru Drona, practiced archery with utmost sincerity and concentration and achieved the highest degree of excellence in the field of archery, even in the absence of physical guru. The three important parameters are: there was no physical guru, so in the presence of virtual guru, and self-practice, that was with sincerity and concentration, and he achieved that. So dear students and all the learned faculty members online today in this webinar, it is my sincere advice that please don't wait for the sixth semester to study the relevancy, reliability and legal admissibility of the digital evidence, or ninth semester to study the glimpses of cyber law. Please don't wait for that. It is expected from you students in general and the law students in particular, the two things most important before you start your session: to know safe use of computer resources. We are using the computer, using laptop, using smartphone, you access the internet, you access Wi-Fi, access the hotspot, use the hotspot, then email, access through the email, websites, the mobile applications, banking applications, all sorts of social media platform, online, internet games. When you are free, you play the internet games, you see the movies on the all internet platform, entertainment platforms. So this is important to know the safe use of all computer resources, all applications. And second, it is also important to know the terminology of digital devices which are used in the cyberspace for preparation, analysis, transmission and storage of information, and should also know the terminology of modus operandi and the trajectory of cybercrime. So the moral of the story is follow Eklavya and study what is necessary to know about the cyber law in the cyberspace at your own, with all sincerity, with the virtual guru at your own, till the curriculum revised by the authority, empowered to do so. My dear friends, this is just an advice as an elder brother from me, because of my experience, what I have experienced, what I see in the society. So that is with you. Thank you very much. Thank you. Namaskar.